Good afternoon, everyone. Thank you for joining us for our today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Differentiating Between Employees and Independent Contractors in Unfair Dismissal Claims. My name is Rachel Ng. I am an associate with Ma Wing Kwai and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by our Datuk Ma Wing Kwai. Our able team today comprises of 28 lawyers and a support team of 17. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-size law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focusing on servicing the needs of individuals and families. Our practice group indicates some of our focus areas, which are supported by talents from both our corporate and dispute resolution team. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation, details of which will be given at the end of this talk. Our speaker today is John Chan. Allow me to introduce John. He is a partner in our Dispute Resolution and Industrial Relations Department. He was admitted to the Malaysian Bar in 2014 and also sits on the Bar Council Sports Committee. We will also be having a Q&A session at the end of the talk, so please post them in the Q&A chat box, which you can find at the bottom of your screen. The talk points for today are unfair dismissal claims under Section 20 of the Industrial Relations Act 1967, contract of service versus contract for services, tests to determine the nature of the contract, and finally, case studies of unfair dismissal claims by independent contractors. Over to you, John.
Thank you, Rachel. Thank you for the introduction, and good afternoon, everyone. I hope everyone can hear me and can see the slides. So I will just start now. Usually when I present on an employment or industrial relations topic, I usually like to start with Section 20 because that is where the court gets its power and where this whole procedure starts. So Section 20 of the Industrial Relations Act 1967, subsection 1 states that where a workman considers that he has been dismissed without just cause or excuse by his employer, he may make representations in writing to the director to be reinstated in his former employment, and this may be filed at the Office of the Director General. In a practical sense, it's the Industrial Relations Department, nearest to the place of employment, which the workman was dismissed. In the case of Hong Leong Equipment, the court held that the legislature has willed that the relationship of employer and workman as resting on a mere consensual basis that is capable of termination by the employer at will, with the meager consequence of paying the hapless workman a paltry sum as damages should be altered in favor of the workman. It has accordingly provided for security of tenure and equated the right to be engaged in gainful employment to a proprietary right, which may not be forfeited, save and except for just cause and excuse. So what this means is Section 20 gives the right to employees to security of tenure and right to employment, which is equal to right to property. So as you are all aware, we all have the right to property unless safe in accordance with law. So meaning if for example, the government wants to take away our property, for example, in land acquisition cases, the law says that reasonable compensation or fair compensation must be paid. So that is the right to property. So coming back to Section 20, right to employment, you have that right unless the dismissal is with just cause and excuse. So every employer has to give just cause and excuse to dismiss an employee. This is the time limit. The Director General shall not entertain any representations unless such representations are filed within 60 days of the dismissal. The proviso that you see at the bottom states that if there is notice of termination, then the 60 days starts after that notice. This is the summarized procedure from the filing of your representation until the industrial court. So what will happen is the employee will file the representation at the department under Borang P1, if I'm not mistaken. Then once the department receives that representation, they will call both parties, the employer and the employee, for a settlement negotiation at the department. Right now, if I'm not mistaken, it is still being done by way of virtual Zoom. But previously, it was done face-to-face at the department. And if an amicable settlement is achieved between parties, then the dispute or the matter ends there. If a settlement cannot be reached, then the department will refer the matter straight to the industrial court, and the court will then register the case and call parties to come before the court. Previously, after negotiation fails, the department will send the matter to the minister, and the minister will decide whether the case has any merits or not. But the government has deemed that to be redundant, and they have amended the law whereby all matters which have failed negotiations will go straight to the industrial court. And this is a summary of the industrial court proceedings. The court's KPI to dispose of a case is between 6 to 9 months, starting with the court issuing a Form F to both parties regarding the mention of case, the first mention, where both parties should be present. At this stage, this is when parties normally appoint solicitors, and the solicitors will then file Form A and Form B. And after that, the court will direct the parties to file their cause papers, starting with the claimant filing the statement of case. 14 days later or 1 month later, depending on what the court directs, the company will file the statement in reply, followed by a rejoinder. Both parties will also file their bundle of documents. and then the court will fix trial dates. And once trial dates are fixed, the court will backtrack a little bit, usually 2 weeks, to get parties to file their witness statements. So then we proceed for trial, where witnesses are called by both sides to testify and to give evidence in support of the respective parties' case. After trial, the court will normally give 1 to 2 months for both parties to also file and exchange their respective written arguments, which we call written submissions. And then after that, usually there will be no oral submissions in court. The court will proceed to consider the submissions and issue a written award to parties. This award is usually issued within 3 months from the last day of written submissions, if I'm not mistaken. Okay, and now for the award, the court's award, the court may order reinstatement of the employee's former position, means back into the company, or if reinstatement is not possible or not suitable, then the court will award compensation in lieu. This is normally calculated 1 month's salary for every 1 year of service. If there is uncompleted year of service, that will not be taken into account. Secondly, the court will also award back wages. For a probationer, it will be a maximum of 12 months. And for a permanent employee, a maximum of 24 months back wages. These can include bonus, incentives, and allowances, and also statutory contributions, which the employee would have gotten if he was not dismissed. Now, in industrial court cases, in unfair dismissal cases, the burden of proof is on the employer, is on the company. So even though it is the employee who will now be called the claimant, even though it's the claimant who files the representation at the department, and he's the one who technically starts the case, the burden is still on the employer, the company, to prove to the court why the dismissal was with just cause and excuse. Common cases of unfair dismissal, misconduct, such as sexual harassment, criminal offenses, breach of confidentiality, and insubordination. It includes poor performance, redundancy and retrenchment, forced resignation, non-renewal of contract. This is usually for fixed-term contract employees, and also constructive dismissal, which may involve pay cuts, victimization or reduction of duties, and also transfers and all that. Okay, so we come to the topic of today, contract of service or a contract for services. The former is an employee and the latter is an independent contractor. Now we look at the law first. Section 2 of the Employment Act states that a contract of service means any agreement, whether oral or in writing, whether express or implied, whereby one person agrees to employ another as an employee and that other agrees to serve his employer as an employee, and this includes an apprenticeship contract. The definition of an employer is a person who has entered into a contract of service to employ any other person as an employee, and this includes agent, manager, and the word employ is, with its grammatical variations and cognate expressions, shall be construed accordingly. In the Industrial Relations Act, the contract of employment is quite similar. It means any agreement, whether oral or in writing, express or implied, whereby one person agrees to employ another as a workman and that other agrees to serve his employer as a workman. An employer in this act means any person or body of persons, whether corporate or unincorporate, meaning if you're just an individual hiring an employee, who employs a workman under a contract of employment, and this includes the government and any statutory authority, unless otherwise expressly stated in this act. And lastly, a workman under the IRA means any person, including an apprentice, employed by an employer under a contract of employment to work for hire or reward, or for the purposes of any proceedings in relation to a trade dispute, includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute, and whose dismissal, discharge, or retrenchment has led to that dispute. In the case of Arun Kumar, the court held that it is trite that in order for this court to have threshold jurisdiction to adjudicate an unfair dismissal claim, the claimant must come within the definition of a workman under the Act. The courts have declared that while there are different types of employment contracts catering for various forms of employment, the industrial court has jurisdiction only over one type, namely the contract of service. Lord Danning has said that it is often easy to recognize a contract of service when you see it, but difficult to say where the difference lies. And this is referring to a contract for services, independent contractor. The High Court has recently set out the difference between a contract of service and a contract for services. And the court said a contract of service is an agreement whereby one person agrees to employ another as an employee, and the other agrees to serve his or her employer as an employee. The employer would need to contribute EPF and comply with relevant statutory benefits, such as annual leave, sick leave, etc., for its employees engaged under a contract of service. On the other hand, a contract for service is an agreement whereby a person is engaged as an independent contractor, such as a self-employed person or vendor engaged for a fee to carry out an assignment or a project for the company. So we can see here the court has put in some factors: contribute EPF, you comply with statutory benefits, annual leave, sick leave. The contract is a contract of service. If it's engaged for a fee on a project basis, then it is an independent contractor under a contract for service. And the court continues, under such a work arrangement of a contract for services, there is no employer-employee relationship, and the employee is not covered by the Employment Act. A contract for services, such a contract refers to a relationship akin to an agency, and generally a person engaged via a contract for services is not an employee. And the court used a few tests to determine the nature of a contract, whether an employment contract or an independent contract. But firstly, in the 1996 case of Ho Kian Ngan, the federal court said that in all cases where it becomes necessary to determine whether a contract is one of service or for services, the degree of control of which an employer exercises over a claimant is an important factor, although it may not be the sole criterion. The terms of the contract between the parties must therefore first be ascertained. Where this is in writing, the task is to interpret its terms in order to determine the nature of the latter's duties and functions. Where it is not, then its terms must be established and construed. But in the vast majority of cases, there are facts which go to show the nature, degree, and extent of the control. A summary of this case says that, firstly, the court will ascertain the terms of contract between the employer and the alleged employee. If it is in writing, the contract, then the court will first look at the terms of the contract to determine the nature of duties and functions of that employee. If it is not in writing, then the court will try to identify based on conduct, which would be the nature, the degree, and the control, which we will go to later. So we can see that degree of control is an important factor, but not the sole criteria. And we come back to the case of Tekun Concrete, the recent case, where the court said that there is no single conclusive test to distinguish a contract of service from a contract for service, but some of the factors to be considered would include the control test, the independence test, the integration test, and the economic reality test, which the court did describe. So for the first, the control test, the court said that this is the traditional test, how much control is being exercised over the worker by the company. The more control that is being exercised, the more likely it is that the worker is an employee, regardless of what the contract says. Traditionally, masters exercise actual control over their servants. However, in more recent days, because people are becoming more specialized, employees will often know more about the subject area they are working in than their employers. So the control test does not therefore look at whether the employer is operating actual control, but rather asks whether the employer could exercise control. The second test, independence test, which the court said is pretty much the flip side of the control test. The question will be, does the worker has independence in deciding how his or her work is to be done? And can he or she decide their own work hours or subcontract out the work, and etc. The third one, integration test. The question to ask is the work being performed under the contract integral to the operation of the business structure as a whole, or is it only works on the side of the main business? One feature which seems to run through the instances is that under a contract of service, a person is employed as part of the business, and the work is done as an integral part of the business, whereas under a contract for service, although done for the business, is not integrated into it, but is only an accessory to it. And this is continuing from that integration test. And further down the paragraph, in this case, it was stated that an employee is a person who is integrated with others in the workplace or business, even though the employer does not necessarily exercise a detailed control over what the employee does. And the fourth test would be the economic reality test. The question would be, is the worker dependent upon the job for economic survival? In other words, can other employment be undertaken by the employee? So we've seen the four tests laid out by Tekun. I've prepared some case studies for you to see how the court has decided on the issue of whether a claimant is an employee and therefore has the right to go forward with the unfair dismissal claim, or if the claimant is actually an independent contractor and then the case stops there because the court will not have jurisdiction over independent contractors. We will start first with Tekun Concrete, where the summarized facts are as follows. The claimant was and this case was not actually an industrial court case, but rather a labor department case regarding salary. But the court still went on to decide on this issue. So the claimant was a crane lorry driver, and throughout his contract, the company had applied the employee's travel allowances as his basic salary. So because of this, the employee complained to the labor department, and at those proceedings, the company took the position that the driver was not an employee because in the contract, the written contract, the basic salary section was left blank, and the driver was always paid on a per trip basis. That was the company's position. But after considering the facts of the case, the court held that the driver was actually an employee under a contract of service because firstly, the contract was titled appointment letter. The driver was given a worker ID number. The contract terms in the written document itself is consistent with an employment contract. There's also an existence of a confirmation letter confirming him to his employment. Pay slips were given to him and they indicated EPF and SOCSO payments as well, which only employees would be entitled to under the law. And there was also control. Under the control test, there was also control whereby the remuneration, annual leave, disciplinary standards were all imposed on the claimant. The claimant had to work every day, and he was not tied down with any single project or delivery of any assignment. And so the court also held expressly that since his working time is dictated by the company, he is economically dependent upon the company. So this is the economic test that we saw earlier. The next case is Lim Bee Hoon and Eduseeds. In this case, this is a constructive dismissal case. And in this case, the claimant entered into a writer agreement with the company Eduseeds for a 1-year period, starting from February 2020. However, in a few months later, 2 to 3 months later, the claimant claimed that she was then constructively dismissed when the managing director informed her that she did not have to work anymore after April. So she filed a constructive dismissal case in the industrial court. And at those proceedings, the company contended that she was actually an independent contractor and her services were terminated because her content quality was not up to standards and also contained plagiarism. And so that's the company's position, that she was an independent contractor and they terminated the services because of these reasons. And the question of dismissal does not arise at all. And yes, the court held that the claimant was not an employee, but was actually an independent contractor because the writer agreement clearly provided that the agreement cannot be construed as an employment contract. So the agreement already expressly said that this agreement is not an employment contract. The agreement also provided for a period of 1 year on showing that the parties' intentions that the claimant was engaged solely for preparing this project, the IGCSE ESL book. The agreement did not provide for a fixed salary, but payment was made to the claimant only upon fulfillment of the work and KPIs. The payment vouchers issued by the company to the claimant also clearly stated rota fees instead of salary. And there was also no payment of EPF, SOCSO, or taxes. So in this case, we can clearly see that the court looked at the agreement. Consistently, the agreement said that this was not an employment contract. And then it looked at the conduct of parties, and also it was consistent that there was no salary paid, there was payment vouchers issued, there was no payment of EPF, SOCSO, or the employees' taxes. The next case, Abdul, Hayy, and 9 Bukit Utama JMB, also a quite interesting case where the claimant, this is from evidence, the claimant initially worked with EcoWorld Property, but then someone from the JMB persuaded him to join the JMB as a security officer. So he was given a letter of offer and he signed the letter of offer. 1 month later, he was then made to sign a fresh letter, a fresh agreement titled Contract for Services, Appointment of Security Officer, which was different from the initial letter of offer. A few months later, the JMB terminated his services and he filed the unfair dismissal claim. So in court, the JMB took the position that the claimant was an independent contractor pursuant to the second contract, the contract for services. But the court looked at the facts and evidence that came at trial and held that the claimant was actually an employee despite him signing a contract for service. The court decided that the mere fact that the contract for service was titled as such is not conclusive enough. The fact that non-payment of EPF and SOCSO is also not conclusive that he was an independent contractor. This was because the terms of the contract for service showed that the JMB had retained control over him, including working hours, a monthly fixed fee, which connoted a salary, and he also had to go through a probation period. Inconsistent with the company's position, the payment vouchers issued by the JMB stated salary and wages as opposed to a fixed fee. And the court held that he had also been enticed to leave his former employment with ECO in order to join the JMB. If he had been an independent contractor, he would have been allowed to retain the right to continue working at EcoWorld, and indeed would have done so. The fact that he had been made to resign from his employment at ECO before joining the JMB had shown that he had been required to enter into a full-time employment contract with it. Thus, the contract for services, despite being entitled as such, had essentially been a contract of service, and the claimant had been a workman with the JMB. So here, in this case, we see that despite there being a contract for service, expressly stating contract for service, and there was also no payment of EPF or SOCSO, the court still went into the other terms of the contract and went into the conduct of parties through the payment vouchers and the enticement of him to leave ECO and join the JMB. And the court took note of all that in deciding that he was actually an employee, despite the earlier circumstances on the face of it. What the court meant here, if he had been an independent contractor, he would have been allowed to retain the right to continue working at ECO. What the court meant here is if this person was indeed an independent contractor, he could have worked for ECO and at the same time worked for the JMB, because that's what agents and independent contractors are able to do. So the fact that you had to entice him and ask him to join you full-time means that the intention was for him to be an employee with the JMB. Okay, next case would be Khairu Norliza against Kool FM Radio. This case is a bit complex in terms of the history of it. So since 2013, the claimant joined the employment of Kool FM as a radio announcer with multiple extensions until 2019. Sorry, this 1 year later should typo. But before 2019, Kool FM then directed her to set up a new company where she was the sole owner, sole shareholder, and the Kool FM entered into an agreement with that new company specifically to employ the claimant as an independent contractor for the sum of 7,000 per month for 2 more years. So the claimant did that and everything was signed, but subsequently Kool FM terminated that agreement with the company, and then she filed for unfair dismissal. So in court, the Kool FM here contended that the claimant was actually an independent contractor because there was this contract for services between Kool FM and her company. So she was not an employee, but she was doing work for her company as an independent contractor. That was Kool FM's position. But the court held that she was actually under the control test. There was a high degree of control over her. She had to work 8 to 10 hours a day on a daily basis. She had to execute formats and music and promotional policies as directed by the company. She also had to do office work, which the court found out at trial. Oddly enough, the salary was also paid directly to the claimant instead of to her company. And she was paid fixed 7,000 ringgit instead of payment based on work done, which would be consistent with an independent contractor. So the court said that it is clear to this court that the claimant was employed as part of the company's overall business of radio broadcasting, and this forms an integral part of the company's business, regardless of how the company had coined the words in clause 6 of the agreement, suggesting that the claimant or LKD Empire, this was the company that she had to form, despite the agreement suggesting that they were an independent contractor. The evidence led in court does not show that parties, especially the claimant, had intended that the contract will be anything but one that creates an employer-employee relationship. The business registration, which was produced in court to show that the claimant, through LKD Empire, was an independent contractor, was done at the insistence of the company before the claimant's employment with the company could be continued. So the claimant had a very weak bargaining power at that time, and the company had taken advantage of the claimant's weak position to cause the signing of the said agreement, which to this court is clearly a scheme engineered by the company. So it's very strong words used by the court in deciding this case based on the facts. This court, having examined the facts of this case, which concludes that the claimant was not employed on a genuine fixed-term contract, there was also overlapping issues of fixed-term contract or full-time contract, and the contract of employment of the claimant with the company is certainly one which is permanent in nature. This court, having concluded that the agreement that was designed by the company is a sham device and was brought into existence purely to defeat the claimant's legitimate rights as a permanent employee. Just a summary on how the court has decided in the cases that we've seen. In general, all cases on this issue. Of course, it's a case-by-case basis, very evidence-based. The court firstly look at the contract between parties, whether written or unwritten. The court will also look at the history and background of the relationship, like we saw in the Kool FM case. And the court will also look at the conduct of both parties, the nature, the degree, and the control of both sides by using the tests that we saw earlier, the control, independence, integration, and economic reality tests. And even with these tests, they are not a fixed criteria for determination. So again, it goes back to, it's a case-by-case basis. It depends on the conduct and how you argue to convince the court when deciding on this case. Okay, some practical tips before I end my presentation. Always do a consistent review of your employment contracts, your policies, and your handbook. If you have independent contractor contracts, review them also. Be consistent in your conduct and relationship with your employees and your independent contractors. Ensure complete and proper filing of employment documents, including letters, emails, including WhatsApp messages. If you have meetings and consultations, make sure you have minutes of them prepared later on. If you have verbal discussions and phone calls, make sure you confirm them in writing or you put them down in writing. If there are queries or inaccuracies raised by either parties, always clarify, reply, respond. Don't leave them unattended to. And of course, the content of your documents or your discussions should always be consistent with the relationship, either employee or independent contractor. I always get signature and acknowledgement of receipt for any documents sent. And if in any doubt or to be safe, always seek legal advice as early as possible. That's the end of my presentation. I think we will now open up for the Q&A session.
Thank you, John, for your insights. I think the questions are slowly coming in. The first question we have today is from Jensen. So Jensen's question is, WhatsApp social media methods, are they considered as legitimate evidence?
Thank you, Rachel, and thank you, Jensen. The short answer is yes. WhatsApp or email or any other social messaging app or SMS are considered legitimate evidence that can be accepted by the court.
Thank you, John. Our next question is from Robert. So Robert asks, how do you see the new amendment to the Employment Act on presumption of employment applying to this area?
Thank you, Robert. Very interesting question, which is quite novel. I don't see much change because the court will still come back to firstly looking at the contract and then looking at the conduct and balancing, of course, both sides' arguments to determine whether a claimant was an employee or a contractor. So if at all these new amendments only add on perhaps more supporting circumstances for either party. So at the end of the day, you need to be consistent in applying these new requirements into your relationship with the employee or contractor as well.
Thank you, John. We have a next question from Simon. So can a husband be an independent contractor appointed by the wife?
Thank you, Simon. Again, the short answer is yes, because the act or the law does not discriminate whether you have no relationship or you have a relationship with your employer. So again, look at the contract, look at the agreement, what was agreed, look at any consideration or salaries paid, even if you're husband and wife.
Thank you, John. Thank you, Simon, for your question. It is now almost time's up, so we will close the Q&A session for today. So thank you, John, again for your insights. Before we conclude, I have a few announcements to make. Firstly, please join us again for our upcoming talks. As you can see on the screen, our next talk is on the 8th of June 2022. The topic will be company constitutions. Are they necessary? And our speakers will be Tommy Wong and Mira Masho. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat now. Thirdly, do follow or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat box, or you can scan the QR code on the screen. Finally, to our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.